So good evening, everyone. Welcome back to our webinar series. We have been discussing all about bankruptcy of individuals since the last session that we had on last Sunday. Today, we will be continuing that. We will be talking about how the moratorium works, what is the interim moratorium, what is the moratorium on after the bankruptcy order, what are the disqualifications and restrictions on the bankrupt, what are the procedures of the COC meeting, the public notice and the claims verification process in case of an individual bankruptcy, discharge order, effective discharge order, or the effect on discharge order. We'll be talking about the fee of the bankruptcy trustee. These are the topics we have thought we would like to cover today. Over to Anil sir to take this discussion forward.
Thank you, Ankit. Good evening to all. And as you see, we've started now thinking that this Sunday in the evening, afternoon, 4 p.m. is a kind of ritual for us. It's about 3 Sundays now, and we hope that we will be able to continue till we have relevant subjects. So this, I think the first that we conducted was the Honorable Supreme Court judgment on Sunil Kumar Jain versus Sandesh Bhatt in the case of ABG Shipyard, and that was primarily for the labor issues. Then we started with the bankruptcy, but before in fact we start discussing clause by clause the bankruptcy process, this was also discussed that how the moratorium under the insolvency resolution process of personal guarantors is helping all the guarantors, all the individuals, and they're using the moratorium to their benefit. And the banks who are enforcing their security interest under SARFAESI Act, and especially where the personal properties of the guarantors are mortgaged with the banks, they are not really very happy with this moratorium, because this moratorium starts right on the filing of the application. And I have seen people have started planning that the application may be kept ready, and the moment bank is trying to take physical possession of the properties under SARFAESI Act, the application can be filed and a receipt can be obtained. Once the receipt is in the hands of the individual who is a personal guarantor to any company, that means that the banks would not be able to proceed against the enforcement of security interest in that case, and it's a substantial time is lost for the banks. This is actually a kind of a scenario which is very clearly emerging out of the individual insolvency resolution process and bankruptcy process. As I said, that I was also the member of the committee constituted by IBBI responsible for implementation of individual insolvency in India. And we have seen clause by clause, we have discussed clause by clause, and we have seen the intent of the committee and the mandate which was given by the government to us, that this individual bankruptcy is not about recovery. It is about the humans. It is about the commercial life of a human. It is about fresh start for a human who have suffered any loss. However, all this is not applicable to any kind of debt which has been raised with fraud. So any debt which has been raised with fraud, that would not be covered. Otherwise, for everything else, the moratorium is available, and that moratorium is presently helping a lot many individuals who are under financial stress, and the banks are enforcing their security interest under SARFAESI Act, so they are taking the benefit of this. So friends, this originally we thought that we will cover this bankruptcy process in 2 sessions, but then the subject is very large, and we also would welcome the questions in between. And in case you would write your questions on the Q&A tab that actually will help Ankit, who is moderating, and he will ask these questions. So I will just share my screen. And in the last Sunday at 4 p.m., we had started this bankruptcy applications, and we have seen that the application under section 121 of the IBC can be filed by the creditor, and application under section 122 can be filed by the debtor, personal guarantor himself. And in that process, I think, Ankit, that's where we want to start, or is there we can start at that level?
See,
So
I think that's the best idea. So a quick recap, perhaps, like within maybe a minute, and then we can start so that those who were not part of our previous episode can also understand.
So this is bankruptcy of individuals, and we have seen that this bankruptcy, just a very quick bankruptcy, is not an automatic process, unlike liquidation. In the case of corporate insolvency resolution process, in case the corporate insolvency resolution process fails, it is automatic liquidation of the company, whereas in case of the individual insolvency resolution process does not result into any repayment plan approved by the adjudicating authority, then the bankruptcy is not automatic. Application has to be filed by the creditor individually or jointly, or by the debtor himself. So what are the circumstances that the application can be filed? In fact, in the last episode, we said that the application under section 94, 95 is considered fraudulent. Then the bankruptcy applications can be filed. Repayment plan is submitted under section 114 is rejected, or no repayment plan is approved by the committee of creditors, or the repayment plan which has been approved by the committee of creditors and adjudicating authority has not been able to implement completely. So that's where all the four circumstances where the bankruptcy application can be filed. We explained that the bankruptcy application can be filed by debtor under section 122, and under 123 was the section for creditors. And then the application by the creditors, we also explained what kind of documents and what kind of forms are supposed to be used. Now, let us talk about the moratorium. In fact, we talked about moratorium in detail for insolvency resolution process of individuals, personal guarantors, where we have seen that the interim moratorium is moratorium sets in when the application is filed. And once the application is filed, the creditors would not be able to initiate any legal action or proceedings against the debtor or any of the property of the debtor. So that was the interim moratorium during insolvency resolution process. And now we are talking about interim moratorium under section 124, which is on filing of the bankruptcy application. So in case we file the bankruptcy application, anyone, even the creditor or the debtor, both can file the insolvency bankruptcy application. Interim moratorium shall commence on the date of application. And this interim moratorium shall cease to have effect on the date of the commencement of bankruptcy. Although it is written that the NCLT will pass the order for commencement of bankruptcy process within 14 days of application, but that 14 days was also written in CIRP process, where it was written in the law that the application will be filed. Within 14 days, the insolvency would start. However, that had not happened, and this also will not happen. And the 14 days is just only showing that there should be priority to admit the bankruptcy process applications. So during the interim moratorium period, any pending legal action or proceedings in respect of any property and debtor, any property and debtor and debt of the debtor shall be deemed to have been stayed. The creditors of the debtor shall not initiate any legal action or proceedings against any property of the debtor in respect of any debt. So these are the moratorium, and then once the bankruptcy order, it is provided in section 126 that the adjudicating authority, may it be DRT or may it be NCLT, the adjudicating authority will pass the bankruptcy order within 14 days of the application. Although it is written in section 125 that the bankruptcy trustee would be appointed, the insolvency professional who actually would 124 the IBBI nomination or confirmation of IP before appointment. So first of all, the creditors will propose the name of the bankruptcy trustee, or the debtor himself will propose the name of the bankruptcy trustee. But as it is provided in the CIRP, that the adjudicating authority shall confirm the particulars of insolvency professionals, and also whether there is any disciplinary action pending before that insolvency professional before he or she is appointed as bankruptcy trustee. But now it is very well mentioned in Rule 8 for personal guarantors, rules for personal guarantors. It is mentioned that no confirmation is required by adjudicating authority from IBBI in case the IBBI has a panel which is shared, which is shared with the adjudicating authority. So now, whenever we apply for IBBI panel, you would see that this now they are also taking consent for individual. They are taking consent for the individual assignments for the resolution process, or because the bankruptcy has not yet started, there is no application as such where the bankruptcy would have started. I'm not sure, but then I think that I've not heard that any bankruptcy application has been filed. So when this bankruptcy order is passed by the adjudicating authority, there are a lot of responsibilities which has been casted on, which has been put on the adjudicating authority. In the case of individual insolvency, adjudicating authority is supposed to provide a copy of the application of bankruptcy and a copy of the order. Number one, it is to be provided to the bankrupt. Secondly, bankruptcy trustee, and also the all creditors within 7 days of the order. So this is a, like, in case any creditor who has say like 100 creditors, then it is the duty of the adjudicating authority to supply two things: copy of the application and a copy of the order to the bankrupt, bankruptcy trustee, and all creditors within 7 days of the order. So the bankruptcy trustee will continue to have effect till the discharge order under section 138 passed. This bankruptcy order and the powers of the bankruptcy trustee will continue till the discharge is given to the debtor. Till the discharge is given to the debtor, the bankruptcy order will continue. Now, once the bankruptcy order is passed, when the bankruptcy of an individual is started, then the estate of the bankrupt shall vest with the bankruptcy, shall vest with the bankruptcy order that will vest with the bankruptcy trustee. The estate of the bankrupt shall be divided amongst its creditors. The creditors shall not initiate any action against the property of the bankrupt in respect of such debt. The creditors shall not commence any legal proceedings except with the approval of adjudicating authority and on such terms as may be imposed by adjudicating authority. So even the creditors also shall not commence any legal proceedings. That's kind of very strong moratorium. However, if a secured creditor does not relinquish his security interest in favor of the bank, in favor of the estate, in favor of the bankruptcy trustee, then the moratorium shall not affect that particular asset. The moratorium would not stay the enforcement of security interest on that asset which has not been relinquished by the secured creditors in favor of the estate of the bankrupt or in favor of the bankruptcy trustee. As usual, no interest would be provided to secured creditors after the bankruptcy order if he does not take any action to realize the security interest within 30 days from bankruptcy commencement date. So there are still some apprehensions that in case of liquidation or in case of bankruptcy, in case the banks do not sell the properties and they keep on accruing interest till the time they sell the property, so that is prohibited under the law, that they cannot charge interest, and they have to realize the security interest within 30 days from the bankruptcy commencement date. So very important two things that we must know, because before somebody takes a decision to go for bankruptcy, there are two things that we must know: disqualification during the bankruptcy process for the bankrupt, restrictions on the bankrupt during the bankruptcy process. So let's first read the disqualification of the bankrupt. So these disqualifications would be effective. Disqualifications would be effective from the bankruptcy commencement date. Any like we have seen various laws where it is provided in some or the other clauses that any person who is bankrupt would not be entitled to do this, or would not be entitled to be appointed, would not be entitled to execute. So there are many acts which actually provide some clauses which are regarding the bankrupts. So there are many things which are not, where the bankrupts are not eligible. So all those disqualification will start effective from the bankruptcy commencement date. The bankrupt, after the bankruptcy order, shall not be able to hold any public office for which the appointment is done by elections. And that can be any public office, local authority or state or center. So and again, like the bankrupt cannot be appointed or acting as a public servant. If he is already a public servant, he cannot continue, or he cannot be appointed as a public servant in case he is a bankrupt. Cannot be elected, sitting, or nominated as a member of any local authority. But these disqualifications are only till the bankruptcy order is recalled or modified, or till a discharge order is passed under section 138. So these are the disqualifications of the bankrupt, and I would now go to the Ankit. Is there any question so far?
Not yet, not yet. So I think it's pretty clear that yes, these are the restrictions and these are the limitations for the bankrupt during the process.
One is the disqualification, and now this is the restrictions. Now the restrictions are that the bankrupt cannot act as a director or cannot even take part in forming and promotion or a management of a company. So he cannot become a promoter, he cannot become a director.
So he has to resign, or there's an automatic resignation as soon as
he has to resign, or the other directors will take the cognizance and will file his resignation, or he will file his exit from the companies. Will file his exit from the companies. I think the other issue which is very, very important is that he cannot create any charge on the asset, on the estate, or take further debt under the bankruptcy trustee special approval, unless there is a special approval. He will have to inform all his partners that he is undergoing the bankruptcy. As one important part is that he cannot enter into a financial or commercial transaction of rupees 1 lakh or more. He cannot enter into any financial or commercial transaction of rupees 1 lakh or more without informing all parties that he is undergoing bankruptcy process. So this is provided in the rules, and the rule 15 says. No, what I'm trying to say is that he cannot, but there is no restriction that he cannot. In case all the parties are informed, then he can still enter into any commercial transaction. He can still enter into any commercial transaction. So my understanding is that this is again good, that only information is required, but then it is not kind of restriction that he cannot. He can, but of course, in case he informs, then only. So the other part is the cannot maintain any legal action or proceeding without specific approval of adjudicating authority. in respect of his debts. But the other part, more important part, is that just a second. See, he cannot travel overseas without specific approval of adjudicating authority. Cannot travel uh, without specific approval of the adjudicating authority. Uh, these restrictions are only till the bankruptcy order is recalled, modified, or till the discharge order is passed. So there are various circumstances where the bankruptcy orders can be recalled, or it can be modified, or it can be even discharge order is passed. So whenever anything such happens, like the bankruptcy order is recalled or modified, or the discharge order is passed, then all these restrictions and disqualifications will finish. All these restrictions and disqualifications will be finished. So this is where we are, like I'm in fact, the restrictions and disqualifications is the only negative point. When a person goes for bankruptcy, these are the only thing, these are which are little negative. Otherwise, so far this law has been made to based on a human angle, and that this should give a fresh start to individuals. The individual would be able to uh, do business again in his own name. He will not remain as a defaulter for 2-3 decades. He will have a right to do business. He will have a right to own assets, and that's what is the law made for. Except for these two things, everything is in favor of, because these are also manageable. Like this is written, cannot travel overseas without specific approval of the adjudicating authority, but he can. I mean, there should not be any reason that he should be restricted to travel. Okay, so now coming next is this statement of financial position. So there are two things. One, that if the application is filed by the debtor or the bankrupt himself, then it is the requirement that he will submit the financial statement. He will submit his financial position along with the application. But in case the application is filed by the creditor, then the bankrupt will submit the statement of financial position within 7 days of the bankruptcy order. And there is a format for this, Form E, which is provided in Rule 11. And that is this is a very detailed format. And we also contributed when this form was being made. And this particular form asks for all the assets, liabilities, disputes, claims, etc. So the bankruptcy trustee also may require the bankrupt or any other person to provide more information about the financial position, but it is the duty of the BT. Bankruptcy trustee can, in short, be called BT. It is the duty of the BT to inquire and seek information about the assets, liabilities, disputes, claims. So this is the commencement of the bankruptcy process. If it is a commencement of bankruptcy process, now the process of public notice, the claims, as we normally have seen in the corporate insolvency resolution process or in the liquidation process, everything will start like liquidation process. And most of the only difference is that there is nothing like secured creditor. There's nothing like operational creditor, or there's nothing like financial creditor. All are creditors. So the public notice, the law is made in such a manner that it is the duty of the adjudicating authority to give the public notice. Because in case we see the invitation for claims in Form C, that is also supposed to be, it is also the primary responsibility with the adjudicating authority. It may be DRT or it may be NCLT. Even the adjudicating authority has been given a responsibility to give a notice to each creditor. I'm repeating, notice to each creditor it is the responsibility of the adjudicating authority as per section 129. So originally what was the intent? Because this particular code was made in somewhere in June 2016, and it was, as far as the corporate insolvency resolution process is concerned, it was notified with effect from 1st of December 2016. However, this law is made since then, and if you would see, the law has actually been passed by the parliament, and it is being notified gradually. So this part is notified now, and but then it was made long back. Considering the difficulties, considering the capacity issues of adjudicating authority, now the Ministry of Corporate Affairs has made Rule 9 and Rule 10, saying that the adjudicating authority may direct the BT to issue public notice instead of doing itself, and also to give notice to each creditor. See, the information of the creditor is available with the adjudicating authority based on the statement of financial position submitted by the bankrupt. Then, in the case the application is filed by the creditor, the statement of financial position is supposed to be submitted within 7 days of the bankruptcy order. So therefore, the adjudicating authority has the list of creditors. So therefore, it is the responsibility of the adjudicating authority to give notice to each creditor. But Rule 9 and 10 has empowered them that they may even direct the BT to do this. So the public notice is again to be issued in leading newspapers, one in English and one in vernacular language where the bankrupt resides. The public notice is also to be displayed on the premises of the adjudicating authority. Public notice to be displayed on the website of the adjudicating authority. So these are the public notice requirements. And then we see the claims have started coming under section 131, and there are regulations 14 to 19. Regulation 14 to 19 deals with the registration of claims. I mean, you can say registration or you can say admittance of claim. The creditors can file their claim within 7 days from the date of notice, and there are forms, Form F, and the claim can be submitted by electronic means, registered post, speed post, or courier. This is provided in Rule 12. Creditors can also file claims till the final dividend is declared. So they can file, because the section 176 says that they can file their claims till final dividend is declared, and the claim will not become time barred as far as the period of submission of claim is concerned. Although it is mentioned that within 7 days, but they can even file the claims till the final dividend is declared. The BT shall give notice to each creditor to submit their proof, because this is not provided in corporate insolvency resolution process, but this is there in the individual insolvency, that the BT shall give notice to each creditor, and these creditors will be taken from the statement of affair. Since the BT is being told that you file a statement of affair along with the application in case you are filing application yourself. Then the BT is told to submit a statement of affair when the application is filed by the creditor. Then by using the statement of affair, adjudicating authority will give notice to all the creditors. In case not adjudicating authority, then the adjudicating authority will direct the BT to do this. Now the proof of security interest will be filed by the creditors in 30 days from the service of notice, and in case not filed, the BT can sell the property after taking approval from committee of adjudicating authority. Now so the creditors, but the question is that in case the creditors are not filing their claim, the BT can sell the property, but permission from adjudicating authority is required. The claim form, in fact, when we asked these various people to submit their claim, that form was being drafted. We also kept in consideration that the some information. See, like when it is CIRP, there are a lot of information which actually can be obtained from various publicly available information highways. One, that it can be ROC, it can be even GST, it can be like various other information that we can obtain about the affairs of a company. But as far as this affairs of an individual is concerned, it is very difficult to get information about the assets, businesses, locations, family, etc. Therefore, in the form, we have actually asked this information from the creditors, whosoever will file the claim, and he is also supposed to give information about the assets if he knows, and to the extent he knows. It is also important to give an information about businesses, location, family, and this is required. This is only to somehow facilitate the information flow from claimants to BT. So the claimants can also provide additional information. There is a column for additional information in case they want to provide any information. Now, section 131 and regulations 14 to 19 further deals with various other situations regarding the claim verification, like claims based on negotiable instruments need to accompany with certified copies of those instruments. Okay, accepted. All expenses for submission or substantiation of claims to be borne by the claimant. It is as also in CIRP. No interest can be claimed for the period after BCD, again, like liquidation. Where secured creditor realizes his security, he will submit proof for the balance amount due from the bankrupt. Again, like CIRP, no difference. Mutual credit on account of mutual dealings would be set off and claim would be proved for the balance after adjustment of mutual credit. Again, this is similar to CIRP. Debt becoming due after application. Now, this is the one scenario that somebody might even say that the application was filed by the bankrupt. However, there was no public notice, and the bankrupt takes some loan or incurs some debt, and then once the debt is incurred, the debt becomes due after the application for the bankruptcy is filed, and the claimant had the knowledge of that application, would not be considered by the BT. However, in case the claimant is not having any information about the bankruptcy application filed by the bankrupt, then he can claim that even after the application, if any debt is incurred, after filing the insolvency application, if any debt is incurred, that would be considered in case the claimant had no knowledge of the application filed. So, Ankit, we've already now speaking for 35 minutes. So do you have any questions, or you can even anything which is coming in your mind?
So, question from Yogendra Pal Singhal. He's saying that if any asset not declared by the debtor and found by the BT, how it can be included in part of the resolution.
So we can actually discuss a couple of things by just stopping this screen. So what is the question?
If any asset is not declared by the debtor and is found by the bankruptcy trustee, how it can be included in part of the resolution? That's his question.
No, any asset in the name of the
debtor.
Bankrupt.
Yeah, bankrupt.
Any asset in the name of the bankrupt, the BT has inherent power to include it in the estate of the bankrupt. The only thing that he has to assure is that the asset is in the name of the bankrupt, and the name.
So that information can be given by some creditor.
That information can be given by the creditors, some relatives, some claimants. This information.
So it is not necessary that information has to come in from the bankrupt.
No, I think during the bankruptcy process, the creditors will also ask the BT to appoint a kind of agency, which is a detective agency kind of agency for asset tracing. Because in insolvency resolution process of individuals, personal guarantors does not require asset tracing. However, the bankruptcy process requires asset tracing, and it is the duty of the bank BT to do the asset tracing. And although there are provisions that in case the assets are not fully disclosed by the bankrupt, then there will be prosecution. But however, I think the banks or the creditors would ask the BT to appoint detective agencies so that the information about the assets and businesses is obtained.
Then we have a question from Mr. Ravi. He says, in case the debtor has only one house, which the value of which is more than 20 lakhs. So then can the trustee sell the entire house and give rupees 20 lakhs to the debtor?
So as I said, like in the last session also, I said when we were drafting this law, it was discussed, and even the regulations were also drafted, that the first right of refusal can be given to the debtor for his own personal residence where he is staying. So the first right of refusal for to buy that property should be with the family of the bank BT. So in case the family of the BT can afford and the family of the BT can pay the amount for the residential house to the BT, and they can even deduct 20 lakhs of rupees, which is required for the purchase of another house. So, but yes, in case now the regulations have been notified, and that particular regulation which was drafted by us and it was discussed in the committee, that is not notified. So now we can safely say that even if it's the only residence, the cost is the market value is 1 crore, and it is the duty of the BT to take over the property and sell it. And after selling, the 20 lakhs rupees can be given to the bankrupt for another home that he can buy for himself and for his family. But I think the jurisprudence will prevail. Rather than selling, I think the courts will pass order that the bankrupt will have the first right of refusal, rather his family would have the first right of refusal. That I think may come.
Right. So I believe this is fine. So so if the house is jointly owned by his wife, then also I believe there is no difference. It remains the same scenario.
No, then only the share of the bankrupt
share
would be
of the
considered.
bankrupt would be considered.
It
But
would
for
not be
that
the
share,
entire
one will
property.
have to understand that what is the source of the money invested in by the wife, and all that I believe will have to be taken care of.
Bilkul, absolutely.
So at the time of discharge order, everything will become normal for the bankrupt. That is right. Like he will become like a person without any effect of the bankruptcy law, or does something gets left, or some effect gets left over his conduct in life or his ability to enter agreements?
See, once the discharge order under Section 138 is passed, and I said that there are some excluded assets, there are some excluded debts. So the excluded debts would not be covered under the discharge order. Excluded debts was explained in the last session, and those are like fines and damages, which is only because of the negligence of a person. I mean, as I had given some examples also, like in case you are using a motor vehicle without insurance and you somehow had an accident, and the person is suffered some injury, and the court has passed an order that you would be giving some kind of there is some fine or there is some damages for somebody's property damage. So all this is excluded. So these debts like fine, damages, or any kind of maintenance which is given, which is ordered by any law, and any kind of maintenance under the marital law, maybe made after the divorce or any other conditions to the children, and also the education loan. So these are some items which would not be waived. It will have to be paid even if a person goes into 10 insolvencies. So this has to be paid. Otherwise, everything else will become completely waived. One more thing which will not get waived is the any debt which is raised with a fraud.
Mm.
So we'll come to the discharge order.
Yeah.
And there are some other question answers also in case you have anything which is coming in your mind, that also you can say.
I think it's good. So let's move forward.
Okay, so we'll again see going ahead, like the registration of claims. The claims have not covered. So these 5 provisions, like future claims, periodical payments, determination of quantum of claim, debt in foreign currency, transfer of debt due to creditors, are similar to CIRP provisions. However, in brief, I will say that in case of any future claim, like can be filed even if not due for payment, and principal amount can be claimed along with the interest accrued till the date of the bankruptcy order. Now, suppose that uh, as a bankrupt, I actually have taken a loan from any person, and that loan is payable only after 3 years. And the only thing is that it has to be paid in installments. And as on the date of bankruptcy order, not that the entire claim, the claim, the interest only would be charged till only till the date of the bankruptcy. As an illustration, like in the case of deep discount bonds, when I say that if you give me 1,000, I will give you 2,000 in 5 years. And as at about 3 years, when the 3 year passed, the bankruptcy starts, and then the claim cannot be for 2,000, because the 2,000 will become due only on 5th year. And as of the bankruptcy commencement date, only after 3 years, the interest can be calculated only for the 3 years and not for the entire amount of the deep discount bond. So this is the kind of illustration that we can use for any understanding about the future claims. Then is the periodic payment, like if there is any obligation on the bankrupt to pay any periodic payment, like in case he has to pay rent every month, or he has to pay earnest installments every month, or he has to pay anything which is periodic. Then in that case, in case of the claim can be made only for the amount due and unpaid to bankruptcy order date. Not that if I have entered into a rental agreement, and I have entered into a rental agreement for say 5 years, and after 2 years the insolvency starts. So the claims from the claim from the any such person would be only restricted to the claim up to the date of order of the bankruptcy. In case of then the third is determination of quantum for claims. In case of any kind of ambiguity, the BT shall make the best estimate of the amount based on information available. Next is the debt in foreign currency. Any debt which is in foreign currency will be valued in Indian currency as per the bankruptcy order, as on the date of bankruptcy order. Now, the other part is transfer of debt due to creditors. If a debt is assigned after submission of claim, both parties to inform the bankruptcy trustee with the terms of assignment. It makes 2 things clarity. One, even after the insolvency order is passed, even after the bankruptcy order is passed, the creditor can assign the loan to any other institution or any other person after the submission of the claim. In case it is assigned, then the information will be submitted to the bankruptcy trustee, and also to it is the duty of the bank BT to inform the adjudicating authority about the change in the COC within 2 days of such change. The change in the COC within 2 days of such change. So now with this process, the first is the interim moratorium, then is the final moratorium, then is the public notice, then is the receipt of claim, then verification of claim, and then finally the BT will within 14 days of the bankruptcy order prepare a list of creditors. within 14 days, uh, basically within 14 days is the uh, list of creditors.
Okay.
So uh, the list of creditors would be made based on one, the application which was filed under section 118, that was during the insolvency resolution process. Then the financial statement which was submitted to adjudicating authority under section 125 or to BT. Claims received under section 130 and above, that's we've all seen now. So these are the three sources of information or sources of the creditors when the BT has to prepare. So the BT will look into all the three documents and finally will make a list of creditors. And in case any person from this list, uh, is not submitting the claim, uh, I think they have to reach out to that person, communicate to that person that you are not submitting your claim. So the list of
So
creditors.
going by common knowledge, the list of creditors would include what? Like we're talking about an individual here. So in case, of course, somebody has taken a personal loan, somebody has become a guarantor for any loan, wherever possible, all that will become a liability of his. Apart from that, the day-to-day activities of a person might involve that person to be involved in some transactions, like maybe he's utilizing some utilities like water, electricity, telephone. So these can be the person's creditors. What else do you anticipate here? Because this list will not be a very large list in many scenarios.
I think this is a very important issue that you've raised. Now, since this law has only been notified for those who have given a personal guarantee, but once suppose like a Mr. Ramnath has given a personal guarantee and Ramnath individual insolvency starts. Now, Ramnath may have a proprietorship concern also. Ramnath may have a partnership firm also. He may have some loans which he has taken against his own residence, or he might have taken some loan against properties. He might have taken some cars. He might have taken some individual loans in the name of his proprietorship firm. He might have taken some bank limits in the name of the
He
proprietorship
might have
concern.
taken some loans from his relatives.
Might have taken. So the list of creditors, or even the suppliers, there may be some business which is running, he is running. There may be some suppliers. There may be some
Statutory liabilities can also
tax
be there.
liabilities.
Yeah.
There can be everything. So the proprietorship concerns can always be there. Then in case he's also a partner in a partnership firm, then of course his share from the partnership firm that actually will become part of the estate of the bankrupt. So that has to be, because it will be duty of the BT to understand the affairs of the partnership firm. And then, or he may have some other companies, he may have shares in other companies, he may have associate companies, he may have subsidiary companies. So he may have many things. What we estimate, and the kind of people, because we see that if a person is doing a good business, then he will have 20-30 companies and he will have shares in all. So all will become as that assets,
Understood.
one side,
Understood.
and the liabilities also.
Understood.
So the COC establishment or constitution, that report has to be given to adjudicating authority within it is the establishment of CSC. There is a report within 3 days from the meeting of the creditors. So bankruptcy trustee within 14 days shall prepare a list of creditors. Then the bankruptcy trustee shall report establishment of COC within 3 days from the meeting of the creditors under section 134. The BT can modify the list of creditors and COC on the basis of the claims, proofs, etc. under section 171. Modified list of creditors and modified COC shall be filed within 15 days from the last date of receipt of proof of debt. So this COC is a kind of uh, perpetual thing, as you have seen that before the final dividend is distributed, any claimant can file a claim. The list will uh, keep on changes, and then the modified list is in any case it is required, and it is supposed to be filed within 15 days from the last date of receipt of proof of payment. It is also important that the list of creditors as modified from time to time shall be available for inspection by the creditors, partners, guarantors, and shall be displayed on the website of the bankrupt. You would probably see the word partners have also come. So that means that in a person, in case he is a partner in a firm, then other partners will also be impacted, because that particular partner's share in the firm, that of course would be uh, a concern for the other partners. So the list of creditors, it should be in the knowledge of the partners. So we are now on the meeting of committee of creditors. The meetings are almost similar as we normally have in CIRP. Within 21 days from the bankruptcy commencement date, issue notice calling a meeting of every creditor. The COC meeting can be convened within 21 days of the bankruptcy commencement date. So the 21 days, the notice will go, and within 21 days, the meeting can be convened. So there is a little overlapping. If notice, 7 days notice is required, so I think the meeting cannot be convened within 21 days. But then anyway, we'll recheck it. So 7 days notice is required, and the contents of the notice is again as same for the CIRP meetings: venue, time, date, options of video conferencing or proxy, etc. should be there in the notice. Notice also shall carry agenda, list of matters to be discussed, list of issues to be voted upon, relevant documents, everything just like CIRP. Notice also to carry details of virtual the conference login ID, name of the IT person, e-voting details, e-voting process, etc. And in case the creditors wants to have a meeting, then they need to have 33% voting share. Then only they can say, BT, please hold a meeting. No, the voting share, and kind of what kind of voting is required for different seasons. So this is very important, because you've seen the committee of creditors has been constituted, the meeting is also done. The voting share shall be in proportion to the debt of the creditor as admitted by the bankruptcy trustee. So when we see this list of creditors, the list of creditors is the all claimants. It is not restricted. All claimants means all suppliers also, government liabilities also, financial creditors, loss. So everyone would be there as a list of creditors. Then out of the list of creditors, the COC would be constituted. And once the COC is constituted, now let us understand the voting pattern. So the voting share of each creditor shall be in proportion to the debt of the creditor as admitted by the BT. The voting share of the secured creditors should depend upon the relinquishment of the security interest. So in case they relinquish all their security interest, then in that case, the total debt would be considered as debt, and they would be given the voting share according to the total debt. However, in case the relinquishment is not done, then full amount of the debt, otherwise unsecured part of the debt. Otherwise,
So with respect to relinquishment, is it similar to the way it works in a liquidation process, that banks are normally inclined to relinquish, otherwise there is a lot of reporting requirement on, and also the fee payment requirement is there. Is it very similar, or is it different with respect to individual bankruptcy?
Now, in the case of CIRP, it is the duty of the RP first to take control and custody of all the assets of the company. Then he would admit the claims from the creditors. Then he will seek, the RP will seek whether you are relinquishing or not. And in case they are relinquishing, okay. In case they are not relinquishing, okay. But the claim, total claim of those, the total claim would be considered as claim, unless the property is sold and the claim is reduced. Unless the property is sold and the claim is reduced. However, in the case of individual, in case they are not relinquishing, they would only be given voting share for the unsecured part of the debt. So this is the basic difference. So in CIRP, I may repeat for the sake of clarity, or in case you have any follow-on question, in CIRP, whenever the relinquishment is done, that means that the entire claim. When the relinquishment is not done, then also the entire claim and the full voting power. However, if the asset, however, in case the relinquishment is not done and the asset is sold by the creditor, then the amount of claim will be reduced. If this happens during CIRP or during liquidation. I hope it's clear.
Yeah. Yeah.
And unless provided otherwise, the COC will require more than 50% voting share to decide a matter or to pass a resolution. So the voting again is a similar manner as in CIRP, that all those who are present, they will vote in the meeting itself, and then e-voting will start who could not vote during the meeting. So when in the CIRP, when we see that somebody is appointing any other person as a proxy, I have not seen any form for attending the meeting, but here it is provided that a proxy also can attend the meeting, and there is a form B that has to be submitted to BT for attending the meeting. Voting can also be done by proxy, who can be appointed, and the results of the voting would be declared within 14 days. So when all is being done, all is getting done, so there's a completion of administration, and distribution of asset of bankrupt in accordance with Chapter 5, because we would be going to Chapter 5 of Part 3 that deals with the completion of, or that deals with the administration and distribution of assets, estate of bankrupt. So that's a separate part. So normally we say 3 parts are there for the entire individual insolvency and bankruptcy. One is the individual insolvency resolution process, where the repayment plan is given. Then is the bankruptcy process. Till now, whatever we have discussed, that is bankruptcy process. And then the third is that the bankruptcy process now is limited to administration and distribution of estate of bankrupt. So the BT to convene a meeting of the Committee of Creditors on completion of administration and distribution. So this is of course much later. Like we have to just see many more things. Like before the final distribution, before the final disposal of one insolvency process for individuals. So here the meeting will be conducted by the COC on completion of the administration and distribution. The BT shall provide a report in the meeting, and COC will approve the report within 7 days from the receipt and will determine if the BT be released under Section 148. BT shall retain sufficient amount from the estate for meeting the expenses of the meetings. So Ankit, till this, and we will only cover the discharge order today, and then we will finish today's session.
Yeah.
After this, like the one part is that even if the BT is continuing with the administration and distribution of the estate of bankrupt, the discharge is certain. Under Section 138, the BT shall apply to adjudicating authority for a discharge order. That means the application has to go to adjudicating authority from the BT side. On the expiry of 1 year from the bankruptcy commencement date, now when can it be applied? On the expiry of 1 year from the bankruptcy commencement date, or within 7 days of the approval of the COC of the completion of administration of the estate of bankrupt if obtained prior to 1 year. Now, in case there is any case where there is hardly any asset and everything has been completed within the first 1 year, then the first we can do the completion of administration of the estate of bankrupt, and then we can go for discharge application. Other party, the BT can apply for an early discharge under section 9, under rule 9, if the assets are not sufficient to meet the cost of process or no further investigation is required in the affairs of the bankrupt. So the two things that has to be assured by the BT, that there are no sufficient assets, and also there is no further investigation is required in the affairs of the bankrupt. Then in that case, the adjudicating authority shall pass a discharge order if satisfied. A copy of the discharge order shall be provided to IBBI also. Now, the effect of discharge. I think this is very, very important. So we leave it to the next session, because this is where the main objective of this law is explained. So Ankit, this discharge is a kind of thing that completely will let us.
Discharge would be the ultimate aim and ultimate objective for a bankrupt to carry on the whole process. So I believe that is important. That is the end result of everything. So great.
I think see, like when the discharge is there, because after the discharge, then we have to discuss the avoidance transactions. We have to discuss the prosecution part of it. Then the administration and distribution of estate, it's very large part. It is just like liquidation, how the assets will be acquired, how the assets will be sold, manner and mode of sale, how the auctions would be conducted.
Okay. That's okay, but more than that, that's there. But more than that, I think practically the most difficult part of doing an individual bankruptcy process, as it is visible to me, is collecting information about all these transactions that might have happened in the past 2 years. Yeah. Because what powers does the bankruptcy trustee use to actually go into the investigator mode? That's the difficulty. In a company's case, a lot of things are very clear, but in an individual's matter, there can be a lot of agreements, a lot of contracts which are not coming to the knowledge of the bankruptcy trustee. So great session, and looking forward to seeing all of you in the next session. And I believe we will also circulate the banner for the next webinar with the recordings of the past 2 ones, so that more and more people can also join the last one, the one in the 3rd episode of this series, so that more and more people can see it. Thank you so much. Thank you, everyone.
So I think we will not extend the sessions beyond 1 year, because otherwise it becomes boring. Yeah. So looking forward to see you all on next Sunday not next Sunday, in fact next Saturday, because the next Sunday we have a family function. So we have actually kept it on next Saturday at 4 p.m. and we would try to complete this bankruptcy. However, still, in case we find that the proper explanation is required, then it might even get extended to 1 more. Bankruptcy is a very large, and it is the same law which is applicable to every individual in the country once notified. So there is no different law is going to be made for this. Thank you very much, all the participants. Thank you, Ankit, for moderating, and it's our pleasure and it's our way of learning. Thank you.
Thank you, everyone.